Hello friends, the topic of discussion today is significant judgment on human rights. Several judgments are there on the topic of human rights, and it couldn't have been a more opportune moment than this one, because Human Rights Day is not very far off. The world over, communities, people celebrate Human Rights Day on December 10th every year in order to mark the Declaration of Universal Human Rights, in the name and style of Declaration of Universal Human Rights, that was done on December 10th, 1948. And that's why every year 10th of December is celebrated as the Human Rights Day. Well, ever since the inception of this great beginning in the field of human rights, India has been a partner in this human endeavor all along. The position or the concern regarding human rights has been prominent in India. The people of India are basically peace-loving in nature. But so far as international recognition or recognition of human rights in a modern fashion is a recent phenomenon. So far as recognition of rights is concerned, first we will have to understand what the rights are actually. Right actually means those claims of humans which have been recognized by society and the law. Claims can be many and various, but not all the claims are moral, not all the claims are justified or sustainable. That's why societies are not forthcoming in recognizing them as valuable rights. But those claims of humans which have been recognized as enforceable rights, they in fact assume the status of rights in the legal sense of the term. Now, the history of recognition of human rights dates back to, in modern form, dates back to the pronouncement of the Magna Carta itself. Magna Carta signifies the first declaration of human rights in the written form too, and that was in the year 1215. It was King John of England who was faced with the uprising and revolt of his barons, and in order to free himself of that predicamental situation, he promised certain guaranteed rights to the people. And the Magna Carta in human history constitute the most illustrious example of a template of human rights that we have today. In whatever form we have human rights, the embodiment of human rights in present times is basically all of a piece with. In fact, they are all offspring of the great pronouncements of human rights made in the Magna Carta. It was in the Magna Carta that for the first time it was recognized that no taxation shall be imposed, no tax shall be imposed on the subjects or people without their representation, without the authority of law. A provision to this effect obtains in Article 265 of the Indian Constitution, which says that no tax shall be imposed or collected without the authority of law. So you can understand here, you can see here that the seed form of the human rights were well embedded in the great pronouncement of Magna Carta in 1215. Trial by jury. Trial by jury, the right to hold and inherit property, right to be heard before any punishment or prosecution. These human rights were first recognized in the Magna Carta, and this was further expanded by the British Parliament in the form of an enactment in the year 1689, when English Bill of Rights Act was enacted by the British Parliament in 1689. December 16th, 1689. And the Bill of Rights constitutes a further expansion or amplification of the great values embodied in the Magna Carta. For example, right to participate in election, free and fair election, regular election, freedom of speech in parliament, right not to be deprived of personal liberty in an undue manner. These important rights were recognized in the Bill of Rights Act 1689. And when the American people through their Continental Congress made a declaration of War of Independence in 1776, these values, these great values of liberty and equality contained in Magna Carta and English Bill of Rights found their most famous expression in the Declaration of American War of Independence in 1776. It has been famously observed by the former Prime Minister of England, Mr. Winston Churchill, that Magna Carta, Bill of Rights, the writ of habeas corpus, trial by jury have found their most famous expressions in the Declaration of American War of Independence in 1776. These themes were further expanded by the American people when they, through the first 10 amendments of the American Constitution, enacted the Bill of Rights in the American Constitution in 1791. So the US Bill of Rights, the American Bill of Rights, the American Constitution as it was ordained and established in the year 1789 didn't contain provisions of fundamental right or human rights as such. It took 10 amendments, though these 10 amendments were made at one single go. In one single go, all these 10 amendments were enacted, and which finally led to the creation of American Bill of Rights in 1791. They also contain a very elaborate list of human rights, rights related to equality, liberty, freedom of religion, right against undue search and seizure by the executive branch or the police of the government, etc. And later on, there are several developments took place the world over. People drew inspiration from these great ideas of equality and liberty, and they carried on a formidable struggle against colonial occupation the world over. They demanded liberty and equality all along. And when they got independence, they all the nations almost through their constitution enacted salutary provisions of fundamental rights under the scheme of their constitution, which are nothing but a refined form of the various strands of human rights. When the Constitution of India was still being framed, in 1948, a significant development on the world horizon took place, and first UN Charter appeared in 1955. However, our constitution making exercise had begun from 1946 only, and a further development happened when the United Nations declared universal human rights. Declaration of Universal Human Rights come about. Declaration of Universal Human Rights came about in 1948. December 10th, 1948, which is celebrated, December 10th is celebrated. That's why this date is celebrated as the Human Rights Day, December 10th, every year. There are 30 odd articles in this Declaration of Universal Human Rights: right to equality, right against exploitation, right to marry, right to fair trial, right to a life of dignity. All these important human rights in a very amplified form are contained in Declaration of Human Rights. And then we have our own Part 3rd of the Constitution, which contains a whole host of several dimensions of equality and liberty formulated in the form of 6 fundamental rights in all. So, part 3rd of the Indian Constitution is nothing but a refined embodiment of human rights. Deliberations, concerns, developments in the field of human rights have never stopped. The world community agreed on certain conventions after the commencement of the Indian Constitution. And two examples in this behalf are worth mentioning. One is International Covenant on Civil and Political Rights. Civil and Political Rights, 1966. And further, of the same year, International Covenant on Economic, Social and Cultural Rights, 1966. So, all these documents are nothing but great pronouncements of the body of human rights. They basically cover the great ideas of equality, liberty and dignity. Likewise, the law defines in our country as well. The name of the law is the Protection of Human Rights Act, 1993. Human Rights Act 1993 defines human right as right to life. Human rights means right to life, liberty, equality and dignity as recognized by law or embodied in international conventions and enforceable by courts. It means the human rights are the whole host or the whole body of human rights basically have to their theme the idea of equality, liberty, dignity and the life itself. One or the other aspects of liberty, equality and life have been covered in the several formulations of human rights that we have through all these documents which have started their journey from the Magna Carta till today. Every day people tend to talk about their rights. They have the tendency to create a new form of human right. Once that kind of claim is recognized, it will become definitely a human right in a particular environment. For example, in some 30 countries of the world, the demand for same-sex marriage has been legally recognized. They have been embodied in law. But in our country, this demand for same-sex marriage hasn't get legal recognition. And in fact, in Suprio versus Union of India case in 2023, Supreme Court denied any such probability to realize soon. But once same-sex marriage is given recognition, it will become a human right, of course, in India too. That depends. So, demand for right never stops. And any demand for any demand of right arising in any corner of the society in any part of the world has the tendency of creating a new form of human rights as such. So, the topic of human right is an ever burning topic. It is a thought provoking topic. It is amenable to endless debate in human society because concerns about right are always there, and especially in a society where the government, the agencies of the government tend to make a misuse of their power, the demand and concern for human rights become all the more important. Now, our country also has given sufficient importance and recognition to the human rights as they obtain world over. In India, they have been incorporated into the constitution, they have been incorporated into statutory laws also. And furthermore, the most importantly, our superior courts have been giving sufficient recognition and importance to the principles of human rights as they obtain in these documents world over or in India. So we are going to refer briefly to several of such judgments wherein the reference to the concern of human rights was there for everyone to see. And a mention in this behalf must be made from the Menka Gandhi versus Union of India case in 1978. And that's how we land up at our subject, significant judgments on human rights. So the first judgment that I would like to refer to is Menka Gandhi versus Union of India. Union of India, 1978, a constitution bench judgment of the Supreme Court. In this case, in fact, the constitutional provision as contained in Article 21, which gives protection to right to life and personal liberty, was expanded, and the procedure established by law as enshrined in Article 21 was interpreted to mean the American due process of law in effect. The Menka Gandhi versus Union of India case represents the greatest concern of all for the protection of human rights in India. Though as much was not said by the Supreme Court in its judgment, but if one were to read between the lines, the conclusion is irresistible that this judgment marks a beginning of greater recognition to the concern for human rights. Because this judgment marks a clear departure from the erstwhile judgment of the Supreme Court in A.K. Gopalan case of 1950. A.K. Gopalan's case of 1950, in fact, shows the list of concern for human rights protection in India. Because Article 21 of the Constitution says that no person shall be deprived of his life and personal liberty except according to the procedure established by law. Means there must be a law. The Supreme Court interpreted this provision to mean that there must be a law which enables the authorities to deprive any person of his life and personal liberty. It matters not whether the law is consistent with, whether the procedure contained in the law is consistent with the concern for human rights or not. Whether the procedure is just, human and fair is not the function to judge whether the procedure established by the law is fair, human and just is not the function of the courts. If the legislature in its wisdom has enacted any procedure whatever, which deprives any persons of his life and personal liberty, then the courts have no right at all to sit in judgment in order to decide whether the procedure laid down therein is just or human or not. It means the Supreme Court in a way refuted the American due process of law to be equivalent with the procedure established by law in our country. If the law says that the cook of the bishop of Rochester should be boiled in oil to be put to death, then we cannot declare that law to be inhuman, because the law says so. If the law is cruel, if the law is brutal, if the law is at the height of the depravity, the courts have no power to declare it as inhuman or null or void as such. The legislative competence cannot be called in question here. Whatever has been done by the legislature cannot be adjudged to be wrong by the Supreme Court or High Court through their writ power. So, A.K. Gopalan's case has done greatest, A.K. Gopalan's case has done the greatest disservice of all to the concern for protection of human rights in India in 1950. And it was like a journey from, it was like a judicial journey from North Pole to South Pole as it were, when in Menka Gandhi case in 1978 the Supreme Court did a complete U-turn as it were and pronounced that the procedure established by law must be a fair procedure. It must be a due process. The procedure must be animated with the principles of natural justice, which says that no person should be condemned unheard. Before a person is prosecuted and punished, let him say his side of this story. Without notice, you cannot take any adverse action against any person. This one is also a principle of natural justice. No person can be a judge in his own cause. This one is also a principle of natural justice. Doctrine of fairness too forms part of the principle of natural justice. So the procedure established by law must be providing for a due process of law in order for it to be declared a valid law enabling the authorities to deprive any person of his life and personal liberty. So this judgment marks the expression of the concern for human right in India for the first time in 1978 in a very landmark manner, because this one was a constitution bench judgment. And this was followed through and acted upon by the subsequent judgments of the Supreme Court in the years to come. For example, the second judgment that we can briefly refer to in this behalf is the judgment of the Supreme Court, in Sunil Batra versus Delhi administration in 1978. Menka Gandhi became sort of a trailblazer in human rights jurisprudence. That procedure established by law is always amenable to challenge in order to find out, in order to ascertain whether the procedure is just, fair and reasonable or not, whether it serves to the protection of human rights or not. This was the message of the Menka Gandhi case, and this was made use of by the Supreme Court in several subsequent cases. The prominent among them are Sunil Batra versus Delhi administration, Sunil Batra versus Delhi administration, (1978). The Supreme Court, speaking through Justice V.R. Krishna Iyer, highlighted the plight of the prisoners in penitentiary, in jail. They face all sort of prosecution. Inhuman behavior are meted out on them. Unspeakable kind of torture they always face. And this judgment highlighted the need for prison reforms in India as well. The further case that we can briefly refer to is the case of Upendra Bakshi, who was formerly a law professor at Delhi University. He also served as Vice Chancellor of Delhi University. Upendra Bakshi versus State of UP. 1981. Several inmates, girl child, who were mentally depraved, were lodged in the protection home at Agra, maintained by the UP government, maintained by the state government. And there also they were facing great deal of persecution, torture, inhuman treatment, sexual exploitation as well. Professor Upendra Bakshi filed an PIL before the Supreme Court, filed a PIL before the Supreme Court. And in this case, the Supreme Court not only directed the release of the persons, the interns there, but also directed the government of Uttar Pradesh to take sufficient steps in order to protect the life, liberty and dignity of the inmates of that jail, of that protection home in Agra. The further case that we can briefly refer to is Rudul Shah versus State of Bihar. Rudul Shah versus State of Bihar is famous for several reasons. It created a new dimension of rich jurisprudence in India. Rudul Shah versus State of Bihar was decided in the year 1983. Several poor people were lodged in one or the other jail of the government of Bihar. Despite their period of detention or the period of punishment having expired already, they were still kept in prison without any reason at all. And when their plight was highlighted by a newspaper, a kind of consternation started haunting the government. And on behalf of one prisoner, a PIL was presented to the Supreme Court. And the Supreme Court here, when the hearing in the case was yet to begin, the government of Bihar directed the release of the petitioner. And when the plea was taken by the government of Bihar at the Supreme Court that we have already released the prisoner, so there is no need to continue a further hearing in this case, this petition has become infructuous, as it were. But the Supreme Court here said that no, we will not stop here only. We are going to direct the government to pay compensation to the hapless victim of your wrongful act of confinement there in the prisons of Bihar. This person suffered ad infinitum because of your apathy, because of your indifference, because of your arbitrariness, and for this you will have to pay the price. Though asking a defaulter to pay compensation to a victim is ordinarily a matter of ordinary civil suit. A person will have to approach the ordinary civil court for the purpose. The Supreme Court said that this is no ordinary matter as such. We are going to do the unprecedented here. We will ask the state government, we will ask the authorities to pay compensation to this person who suffered the best years of his life for no reason at all in jail because of the arbitrariness of the state government. So this judgment is famous for this one particular reason, that while hearing a writ, the superior court, means Supreme Court or High Court, not only can issue writ in order to enforce the fundamental right, but they can also direct for compensation to be paid to the victims of violation of fundamental rights. And this judgment of the Supreme Court was relied upon by the Supreme Court itself in several successive judgments. And in this behalf, the further mention we can make of is that of Sebastian M. Hongre versus Union of India's case in 1984. Sebastian N. M. Hongre filed a PIL at the Supreme Court against the government of India. He was a student studying at JNU in Delhi. He was from Nagaland state of India, and there, due to the situation of disturbance of peace, army were deployed in the state of Nagaland. The Sikh regiment of the Indian Army was posted in the Ukhrul district, of Manipur and the neighboring parts of Nagaland. And one or two people from the nearby villages were picked up by the members of the army in order to conduct interrogation against them. And these two people never returned their home, and it was alleged or feared that they were killed in custody of the army because they remained traceless for several weeks. Their family members were running from pillar to post in order to know about their whereabouts, but nothing was coming of their no relief was coming in their way. Feeling aggrieved, though they could do nothing, but one public spirited individual from Nagaland appeared before the Supreme Court, filed a petition, and thus Sebastian Hongre became the petitioner here, and he filed a petition. And in this case also the Supreme Court conducted the hearing, and making use of the jurisprudence developed in the Rudul Shah case, here also the Supreme Court directed the Union of India to pay copious, generous amount of compensation to the bereaved families of the missing persons there. The further case that we can refer to for the purpose of human rights is the Olga Tellis case. Olga Tellis case. Olga Tellis versus Bombay Municipal Corporation. Bombay Municipal Corporation, 1985. Olga Tellis, a journalist, had filed PIL at the Supreme Court because the pavement dwellers there in Bombay were being removed by municipal authorities. The pavement dwellers had taken the plea at Bombay High Court that they do not claim that they have a right to, fundamental right to sleep on the roads or the pavements, but they sleep on the roads because they have their workplaces nearby. If government or municipal authorities try to locate them or zone them out somewhere, then their workplaces will be lost to them. They will be deprived of their right to livelihood. And this case somehow was pronounced upon by the Bombay High Court, and the judgment went against the pavement dwellers, taking up cudgel on behalf of the bereaved people, the destitute people. The Indian Express journalist Olga Tellis approached the Supreme Court, and in this case the Supreme Court had famously declared the right to work as part of right to life. The right to work as part of right to life contained in Article 21 of the Constitution. Mind you, this trend of reading several other rights as forming part of right to life in Article 21 was started in Menka Gandhi case itself. That right to life contains a bundle of rights. It partakes of several such other rights also as are indispensable for existence of human being. To have a meaningful life, the right to life simply doesn't mean cattle type existence of life. In Menka Gandhi case, Justice P.N. Bhagwati had famously declared that our fundamental rights weave a pattern of guarantee on the basic structure of human rights that obtain the world over. And our fundamental rights impose a negative obligation on the state not to encroach arbitrarily on the life and liberty of people. So this Menka Gandhi judgment further was relied upon in order to expand the ambit of right to life as it obtains in Article 21 of the Constitution. Accordingly, in Olga Tellis case, the Supreme Court declared that right to work is part of right to life in Article 21 of the Constitution. The doctrine of waiver also was enunciated in this very case itself. No person can waive or give up or surrender his or her fundamental rights by any written declaration. The usual doctrine of estoppel as it obtains in the law of contract shall not apply to fundamental right provisions. No person can surrender his fundamental rights in lieu of something else. It cannot be a bargaining chip for any individual that I will surrender my fundamental right in lieu of certain concession to be given by the state. Further, in Neelabati Behra case, Neelabati Behra case is a very poignant type of case. It's a very heart touching kind of a case. It will make you emotional. Neelabati Behra was state of Orissa. Now the state of Orissa has a name, different name. R word has been replaced by D. Odisha it has become. Neelabati Behra versus state of Orissa was decided by the Supreme Court in 1993. In this case, a specific reference was made by the Supreme Court to Article 9, Clause 5 of the International Covenant on Civil and Political Rights of 1966. In this case, what had happened, that one poor boy, Suman Behra, was picked up by the police. in the Saraikela police station of the Sundargarh district of the Orissa state, and his dead body was found lying near a railway track the next day. It was suspected that the police had caused custodial death of the poor destitute Suman Behra, because he was in the custody of the police. They primarily were responsible for his safekeeping. How could he manage to run away from the police station? The police had no explanation to offer. The police only said that he had cut the rope through which he was tied up at the police station, and somehow he managed to run away in order to escape the process of law. And maybe due to accident he would have died. When the matter came up to the Supreme Court, in fact the mother of the deceased Suman Behra wrote a letter to the Chief Justice of the Supreme Court, and the Supreme Court, by way of Article 32 of the Constitution, took cognizance of this letter, treated it as a writ petition, started hearing the case, and in this case the Supreme Court first directed the district judge of the Sundargarh to conduct an inquiry as to how it all happened, what really is the true story in this case. And the district judge of the Sundargarh district, Orissa, came up with a finding that prima facie this case is one of custodial killing by the police, because it doesn't look like an accidental act, that the victim might have been run over by a moving train, etc. Because the injury mark that is there on his body shows that this was as a result of, these injury marks were as a result of merciless beating that might have been given to him when he was in police custody. So based on the preponderance of evidence, the Supreme Court utilized the wisdom of the Rudul Shah case and directed the government to pay compensation to the mother, the petitioner of the deceased. So this also is a very great case in the field of human rights. Here in this case, Nilavati Behra case, as I told you, Article 9 Clause 5 of the International Covenant on Civil and Political Rights was referred to by the Supreme Court, and this article of the International Covenant says that persons victim of custodial torture and killing have a right of compensation, have a guaranteed and enforceable right of compensation. This judgment, like other previous judgment as well, highlights one more time that the international conventions on human right ignite judicial thinking in India as well. Lessons, inspirations can be drawn from those conventions, those pieces of wisdom as they obtain in the formulations of human rights the world over in the form of several of such conventions, the Declaration of Human Rights including. So our courts have been very forthcoming in drawing upon from the wisdom and pieces of international human rights. One more example of a judgment that I would like to quote is that of Visakha versus State of Rajasthan. Visakha versus State of Rajasthan is a very well-known case. Visakha versus State of Rajasthan, (1997), another landmark judgment of the Supreme Court. The background of this case is concerned with the incident of gang rape committed upon a social worker. But this case in a way highlighted the plight of women who go outside, engage in work, and they face all sorts of persecution, sexual harassment, and the gruesome rape, incidents of gruesome rape as well. So what measures indeed should be taken in order to give them protection against acts of sexual harassment perpetrated upon them by their colleagues, etc. And in absence of any legislation in this behalf, the Supreme Court went on here to lay down certain guidelines to be binding upon authorities, to be binding upon private players as well, in order to ensure the prevention of sexual harassment of women at workplace. So this case is famous for guidelines as to prevention of sexual harassment of women at workplace. Of women at workplace. The judiciary doesn't make law, but sometimes it of course declares the meaning of the law, and in the process it elaborates the law as well. And that's why we say that judiciary interstitially sometimes make law. The original function of the judiciary is not to make law as such, but in order to fill up the void or gap by the legislature, the judiciary does a step in and make certain laws as well, declare certain law as well. This one is an example of this kind. And the guidelines was made use of by the legislature when the Parliament of India in 2013 made a law, Prevention of Sexual Harassment of Women at Workplace Act 2013. Now a law has come to stay here. The law was enacted by the Parliament of India. The name of the law is Prevention of Sexual Harassment of Women at Workplace Act 2013, which largely incorporates the guideline that was made out by the Supreme Court in this particular case. The further case that we can refer to is that of one of Chairman Railway Board. What was the number of the case in the, this we can call case number 8. Now let us come to the 9th. Chairman Railway Board. Chairman Railway Board. Chairman Railway Board versus Chandrima Das. Chandrima Das, year 2000, Supreme Court. In this case also, Universal Declaration of Human Rights 1948, International Covenant on Civil and Political Rights 1966 was also salutarily referred to by the Supreme Court. Here also, utilizing the jurisprudence set by the Rudul Shah case, the Supreme Court upheld the judgment of the Calcutta High Court, wherein the government was directed to pay compensation to a victim of violation of fundamental right. In this case, one Hanufa Khatun, she is not the petitioner here. Hanufa Khatun, a lady from Bangladesh, was paying visit to India. She had come to Calcutta and she was on her way to Ajmer Sharif in Rajasthan. And when she came at Howrah railway station in West Bengal in order to get on board a train for Jodhpur city in Rajasthan, she found out that she didn't have a confirmed ticket. She only had a wait listed ticket, so she was constrained to wait for some time. She approached a travelling ticket examiner and requested him to make arrangement for his travel. But he directed, the TTE directed her to approach some other person, and those other persons in a conspiratorial manner took her to some secluded place, intoxicated her and committed repeated acts of gang rape upon her. And When she came back again to the railway station, she was again taken back to some other place where she was subjected to physical injury as well. And when a lot of outcry was raised in the process, the authorities intervened and thus her life could be saved in the process. In this case, a lady advocate Chandrima Das filed a PIL at Calcutta High Court, and Calcutta High Court directed the railway administration to pay a compensation of rupees 10 lakh to the victim of the gang rape, Anufa Khatun, and this judgment of the Calcutta High Court was appealed to the Supreme Court of India, and that's how the appeal came up to the Supreme Court. But in this case also the Supreme Court relied upon the judgment of the Rudul Shah case in 1983 and directed the government to pay the amount already fixed by the Calcutta High Court in its order. Here also the Supreme Court observed that though direction to pay compensation is ordinarily a civil matter, it has to be looked into or tried by or adjudicated by the court of the lowest grade, which is competent to try a civil suit. But this is not an ordinary case. This is not a concern or a subject matter for private law to take cognizance of. Such kind of incidents can only be sufficiently dealt with by public law only, and that's why a writ will certainly issue in order to cause the railway administration to pay compensation to the hapless victim. So in this manner, human right of people have been, be they Indian or be they foreigner, if their human rights have been violated in India, they have been given sufficient remedy by our courts. So we can say it for sure that concern for human rights in India hasn't diluted a little bit at all, and the concern for the human rights is well manifested in the several judgments of the court, in the way the authorities are required to act in accordance with the provisions of the law, speak volume about the greatness of the concern that we have about our fundamental rights and by implication the several human rights. Now, the most recent case that I can feebly refer to is the Hadia case. In fact, the name of the case is Safi Jahan versus Ashokan came 2018. When the Supreme Court declared in this case that right to marry according to one's choice is part of right to life in Article 21 of the Constitution, in fact it was referring to one article of the Universal Declaration or Declaration of Universal Human Rights, 1948, which says that right to marry and right to family are one of the most important human rights world over. So if a person, a Hindu girl converts to Islam and she picks up a partner for her life, then how come can court prevent her from doing so? How can any person for that matter prevent her from doing so? She has a right to marry according to her own choice. So in this manner, the horizon of human rights, the expanse of human rights has undergone manifold amplification, and the days ahead also hold a good deal of promise that an aware citizenry will hold the authorities to account wherever the protection of human rights is concerned. As has been famously observed by a scholar, that eternal vigilance is the price of liberty, and liberty constitutes the greatest of human rights of all. Eternal citizenry will certainly take care of the regime of human rights that we have in our country. We will hold them accountable. We will ask pertinent questions. We will appear at courts, maybe through PIL, to vindicate our claims to human rights. Thank you.